Okay, in this video I'm going to take a look at getting a divorce in Ireland step by step. This is a fairly basic guide, but it'll give you a good idea of the steps involved in getting a divorce. Step number 1 would involve mediation and legal advice. Mediation is always recommended because it may help or revive or heal a fractured relationship, but mediation would be recommended, and it's something that the solicitor will have to give a certificate about as well prior to commencing legal proceedings, but mediation will be strongly recommended. So consider mediation first. Then consider legal advice. You may well need legal advice arising from the mediation, because the mediation may have led to some sort of an agreement, some sort of a separation type agreement that you'd be hoping would agree or would set the terms for any agreed divorce down the line. And remember, in order to qualify for a divorce, be eligible for a divorce, you must have been living separate and apart from the other spouse for 2 out of the previous 3 years. So, mediation, legal advice. The documents then you're going to need to commence your divorce. You're going to need 4 documents: family law civil bill, affidavit of means, affidavit of welfare if there are minor children, and a statutory declaration from a solicitor who has advised you about the benefits of mediation and who has given you a list of mediators if you want to pursue mediation. In order to commence legal proceedings then, you send the papers in triplicate to the Circuit Court office for issue. Once the family law civil bill / divorce proceedings are commenced, you'll need to serve the other party. But firstly, you or your solicitor will serve or will send the papers to the Circuit Court office for issue in the first instance. You serve the other party then by either registered post or in person. If you have a solicitor, your solicitor will do this for you, and the other party or spouse may well have a solicitor as well, so that's how it's done. If not, then you'll need to, if you're doing it yourself, serve the other person by registered post or in person. The respondent then must enter an appearance. If he or she agrees with the divorce, then he'll send a letter or should send a letter confirming agreement. He must also send affidavits of means and welfare to you or your solicitor. If he does not agree, then it's going to be a contested divorce and he or she must enter a defence. The respondent must also file an affidavit of service. In due course then you're going to obtain a court date. This is done by notice of motion if there is agreement between the parties. If there's no agreement between the parties as to the terms of the divorce, then it's going to be a contested divorce. The case will need probably to go into case progression by the county registrar, who will identify the issues that need to be addressed and the paperwork which will need to be put in order for the case to be put into the judge's list. Only a judge, remember, can grant a divorce. When it goes into the judge's list, then you're going to have a court date, a court hearing date. The applicant will give evidence. Sometimes the judge may also want to hear from the respondent. The judge must ensure proper provision for dependent children and that all other matters are dealt with to the judge's satisfaction. If so, the divorce will be granted. If there is no agreed terms, however, you're going to have a court hearing, and the judge obviously will have to ultimately rule and make provision and make a decision about the various aspects of the divorce and on what orders basically are made for the divorce. On the other hand, if it's not contested, if it's simply agreed by both parties and both parties should try to reach agreement, well then the judge will grant the divorce in the normal course of events, provided he or she is satisfied that proper provision has been made. The divorce will be granted on the agreed terms between the parties. Once that happens then, or indeed once a hearing has been held and a divorce has been divorce order has been granted by the judge, then the divorce order will issue from the court office, the Circuit Court office, in due course. all divorce proceedings in Ireland, if the value of the assets are less than €3 million, will commence in the circuit court. If it's above €3 million, then you're looking at the High Court. So if you're watching this video, the likelihood is you're going to be in the circuit court in the relevant circuit, and you will have some discretion, some choice as to which circuit you choose, but you'd want to speak to your solicitor about that. And obviously which circuit you choose may be a decision that will cause you some concern, or you might have to give some thought to, or it may not. Also, just remember, you will need to have lived separate and apart for 2 out of the previous 3 years, but you could be living in the same house and be living separate and apart. Anyway, I hope you find this video useful. If you do, I'd appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. I make videos about Irish law, Irish business, all sorts of stuff. Thanks a lot.